Hello friends. Today we are going to discuss about Medical Termination of Pregnancy Act 2021. I'll be discussing about case laws in this video. I'm Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about the recent landmark judgment from Supreme Court of India with regard to Medical Termination of Pregnancy Act 2021. Before we move into the case laws, let's look into some of the provisions of Medical Termination of Pregnancy 2021. If we look into the section 3, the permission to do MTP is given to one registered medical practitioner if the pregnancy does not crosses 20 weeks. Here, the registered medical practitioner should certify that continuation of pregnancy would involve a risk of life of a pregnant woman or of a grave risk to her physical and mental health. Then the medical termination can be carried out. There is also a substantial risk that if the child were born, would suffer from serious physical and mental abnormality. Here the word serious physical and mental abnormality has to be kept in mind. To summarize, one registered medical practitioner is required if the pregnancy is not more than 20 weeks. If the pregnancy is between 20 to 24 weeks, in such a scenario, two registered medical practitioners have to certify and then MTP can be carried out. Again here, the continuation of pregnancy would involve risk to the life of the pregnant woman or of a grave injury to physical and mental health of the pregnant woman. Further, there is a substantial risk of the child where born would suffer from physical or mental abnormality. Here again, it has to be substantial. That's the word used. Suppose if the pregnancy crosses 24 weeks, in such a scenario, then the medical board has to be formed and the medical board will give opinion. If the termination is required to save the pregnant woman's life, a single RMP is more than enough. If there is a substantial fetal abnormality, then the medical board has to give permission. So please understand, if the grave life-threatening injury is going to occur, then no need to go for medical board, a single registered medical practitioner can give. But whether if it is related to the congenital abnormality, it has to be substantial, then only the medical board can give permission for MTP after 24 weeks. Further, it is further qualified under Rule 3B of MTP Amendment Rules 2021. It says, the survivor of the sexual assault, rape or incest, they can undergo MTP. Minors, change of marital status, that is, if the lady becomes widow or if there is a divorce. Women with physical disability, mentally ill women including mental retardation can ask for MTP. The fetal malformation. The fetal malformation needs to be incompatible with the life of the child if it is born, and it may suffer from a severe physical and mental abnormality causing severe handicap. Further, humanitarian settings or disaster or emergency situation as declared by the government. Why this humanitarian or disaster? Please understand, during COVID, there were many MTP were supposed to be done because of various reasons. Because of the lockdown, the access to healthcare was not possible. Hence, during disaster or humanitarian settings, when the government has declared, MTP can be carried out. Now, let's look into some of the case laws. One of the important cases which came in front of the Supreme Court was with regard to Down syndrome. But this was under MTP Act of 1971. In February 2017, A mother, a resident of Alibag, Maharashtra, belonging to a lower middle class socioeconomic status, already she had one child with disabled, and during her antenatal checkup, that is at the 22 weeks, she came to know even this child also has trisomy 21, that is Down's syndrome. That is a chromosomal aberration which leads to congenital anomalies in the child. Since the parents had already a disabled child, they did not wanted this child to be born. And they were from the lower middle class socioeconomic status, and it was hard to take care of two disabled children. Hence, they approached the court for abortion. By the time they reached the hospital, it was already 24 weeks. None of the medical board gave permission. Hence, they approached the Supreme Court. Please remember, this was in 2017, before the amendment took place. Once it went to the Supreme Court, again it asked for a report from the medical board from KEM Hospital, Mumbai. So the couple had to go back to KEM Hospital, get the chromosomal anomaly tested again, and they came back. By the time it was already 26 weeks. The medical report given by the medical board, it said there is no harm to the health of the mother. The fetus has the possibility of being born with mental and physical abnormalities, but has a chances of survival, and thus abortion is not warranted. This was the report given by the medical board. Now, let's understand what is this Down syndrome. For a moment, we will hold on to the Supreme Court judgment. Down syndrome, as I mentioned, trisomy 21, that is chromosomal 21, has 3 copies. It has the child when it is born, it may have mental retardation, flat head, abnormal ears, many loops of the finger, simian crease, congenital heart disease, enlarged colon, abnormal pelvis, umbilical hernia, broad flat face, mongoloid faces, short hands, and also arched palate, and various other congenital anomaly can be seen. The classical one are flat face and eyes, large tongue, short neck, simian crease, that is a crease in the palm can be seen, ears which are abnormal shape. These are the hallmark of Down syndrome. So as you can see here, trisomy 21, there are 3 copies instead of 2 copies. And this occurs for various reasons. One of them is non-disjunction leading to trisomy 21. That means 95% occurs because of non-disjunction. 4% is because of translocation of the chromosome 21. And only 1% is mosaicism. So the maximum time is extra copy of chromosome 21, meaning that there are 3 copies of chromosome which occurs because of the non-disjunction. So that is the commonest 95% in Down syndrome. Since the child can survive, the child can have mild mental retardation, the apex court refused to give permission to medical termination on the grounds telling that it has already crossed 20 weeks. This was under MTP Act of 1971 because the case came in 2017. Since the statutory time period of 20 weeks was crossed, and Down syndrome children are very well known to survive, may have congenital abnormalities, but the Supreme Court refused to give permission for MTP. This case has been discussed in Indian Journal of Medical Ethics by Nimbalkar and Patel in 2019. I request my viewers to go through this article, which have been discussed in thorough. Now let's move on to another important case, Vignet. This was in 2022. This is again from the Supreme Court. X versus Principal Secretary of Government of Delhi. Here we are going to use X. The simple reason is Medical Termination of Pregnancy, amended in 2021, clearly says that the mother's name or the lady who comes for medical termination of pregnancy, her name should not be revealed to anyone. Hence, the Supreme Court does follow the same thing. Hence, the name of the lady who has come for MTP will not be revealed. Here again, a lady who is an Indian citizen, a permanent resident of Manipur, she is working and residing in New Delhi. She is 25-year-old, unmarried, and now she has become pregnant, carrying an intrauterine pregnancy of 22 weeks. And this pregnancy was secondary to consensual sexual relationship with her boyfriend. Unfortunately, the last minute, her boyfriend refused to marry her. That is, her partner refused to marry her. Hence, she wanted to undergo MTP now. She went to many hospitals for termination. She reported that she did not want to carry this child because there is a high social stigma, harassment for an unmarried woman having a child. Further, she also said she is from a lower socioeconomic status. She will not be able to take care of the child alone. And she also said having a child at this point of time, when her partner refused to marry her, raising that child will be mental harassment to her. In this social context, the appellant stated that continuation of this unwarranted pregnancy means have an immense injury to her mental health was stated. She went to various hospitals. None of the hospital accepted medical termination of pregnancy. Later, she went to High Court asking for give orders to the hospitals to conduct MTP. In this regard, the Delhi High Court rejected her MTP, telling that it has already crossed 24 weeks of statutory period. That means she cannot undergo MTP now, since it is a consensual relationship and she was unmarried. And even the High Court said that MTP Act 2021 does not cover for an unmarried woman. This was the ruling given by Delhi High Court. Hence, she appealed to the Supreme Court. Supreme Court said that very categorically and clearly. It seems to us that the Rule 3BA is restrictive and narrow interpretation would render it useless and it becomes unconstitutional. For it to deprive unmarried women of the right to access safe and legal abortion between 20 to 24 weeks, if they face a change in their material circumstances similar to the married woman. That was the interpretation of the Apex Court. The Apex Court was very clear. If there is a change in her live-in relationship or a partner similar to a married woman, then it has to be given importance. And the Apex Court upheld, telling that right of the reproductive autonomy, dignity, and privacy under Article 21 given for a married woman is also should be given to unmarried women. That means the right of choice, whether to have a baby or not to have a baby, is equivalent to a married woman. That means you cannot differentiate a married and unmarried woman for the purpose of MTP. This was the judgment given by the Supreme Court by 3 bench judges, which was led by our past Supreme Court Chief Justice Lord Dhananjay Chandrachud Singh. So this was a landmark judgment with regard to medical termination of pregnancy for unmarried women. Now let's move into another important judgment, X versus Union of India 2023. Here, the petitioner is a married woman who is 27-year-old. She has a husband and 2 children. The younger one was 1 year old. The petitioner stated that she did not discover the pregnancy because she was breastfeeding. Because of breastfeeding, there was amenorrhea, and she became pregnant and she could not know that she was pregnant. The petitioner visited the doctor at 22 to 23 weeks because she had nausea, vomiting, that is, morning sickness. The doctor asked her to go undergo ultrasound. In ultrasound, they confirmed she is having 24 weeks of pregnancy. Unfortunately, she had already 2 children, and the last one was only 1 year old. The petitioner asked for MTP. The hospitals refused to do MTP because it was already 24 weeks of pregnancy. She asked for pregnancy to the Supreme Court so that she should not be differentiated from a married or unmarried woman. She also stated that she had a postpartum depression in the previous pregnancy. Hence, having another child will be a risk for her mental health. That was one of the important points she raised. Further, she said her husband is only earning member of the family. Already they have 2 children. They are from low socioeconomic status. Hence, taking care of the third child will be very difficult. The Supreme Court asked All India Institute of Medical Science to set up a medical board. The medical board was set up, and the medical board gave a report telling that it was 26 weeks of pregnancy and MTP can be permitted. She had already 2 children which were born through lower section. Caesarean section was done, and past history of depression was there. Hence, the Supreme Court also accepted and asked the All India Institute of Medical Science to do MTP. The medical board was in favor. Hence, even the All India Institute of Medical Science report and the Supreme Court were on the same line. However, one of the medical doctor of the medical board raised an objection. She wrote an email stating that now we have to kill the baby in the utero before we do MTP. She asked the clarification from the court. At 26 to 28 weeks, during that period, if you want to do MTP, we need to inject potassium chloride to the heart of the fetus, stop the heartbeat, then induce labor. Then only you are going to have a fetus which is already dead. If you induce abortion without stopping the baby's heart, there is high possibility a live child will be born. That means here we are doing euthanasia. She asked the Supreme Court to clarify whether the doctor should perform this euthanasia by injecting potassium chloride. Now the Supreme Court got jolt. Now a 3-bench judge was called in to decide about this case, and it was presided by, again, our past Chief Justice of India, who took this matter into his hand. The AIIMS Medical Board was again called for, and they were asked why there were 2 reports, one from the medical board and the other from a member from the medical board. AIIMS Medical Board again gave a submitted report telling that there was no fetal anomaly and the mother's mental health is under control, she is under medication, and MTP need not be done. In this background, since it was already crossed to 26 weeks, Apex Court gave a verdict The length of the pregnancy was 26 weeks and 5 days, that is almost 27 weeks. A medical termination of pregnancy cannot be permitted since there was no substantial fetal anomaly or mother's mental or physical health problem. Further, the Supreme Court also said that the pregnancy has to be done free of cost at AIMS, and also said if the parents cannot look after the child, they can give for adoption. It is left to their decision later part in their life. So, my dear friend, this decision was a landmark decision where the Supreme Court did not allow termination of pregnancy where it was crossed 24 weeks. Now let's discuss about X versus State of Maharashtra 2024. This is another important landmark judgment. Here, X is a minor who is hardly 14 years old and she was assaulted sexually by some person in the neighborhood. That occurred in September 2023. The incident came the forefront only when the X revealed the incident in 20th March 2024. By that time, she was having a child or a pregnancy of 25 weeks. Immediately, FIR was registered against the perpetrator, and then the child was taken for MTP. The Government Medical College at Mumbai examined the child and said that MTP be permitted with the permission of the High Court. Hence, the parents had to go to the High Court of Mumbai asking for permission for MTP. The High Court dismissed the writ petition, telling that it has already crossed the statutory period of 24 weeks. See, here is a child who is 14 years, and already 26 weeks of pregnancy because of rape. And the High Court said, we cannot allow MTP. Hence, the parents moved to the Supreme Court of India. The Supreme Court asked for a repetition of a medical board again so that get a new perspective with regard to the pregnancy. In this, again, the medical board opined the continuation of pregnancy against her will negatively impact our physical and mental health well-being of the child. The termination can be carried out at this stage equivalent to the risk of carrying the pregnancy till the full term. So the apex court ordered for MTP because it was a rape and she was a child of 14-year-old. Now the medical board formed a team which they wanted to do MTP of the child. Now, when they went for consent from the parents, initially the parents agreed and gave consent for MTP. When the MTP was explained, the mother withdrew the consent and said, we want a healthy child. There was a change in statement both by the parents and even the child was changing on everyday basis. Hence, the medical board from Mumbai became apprehensive, again reported back to the Supreme Court telling that the parents of the child are not giving consent or they're changing their consent on day-to-day basis. Of course, the parents were apprehensive. She's hardly 14-year-old, and now the doctors explained they are injecting potassium chloride to the fetus heart, and there is a possibility it may spill over and may have some side effects on the mother. So the parents were very apprehensive. Hence, they were changing the consent. The medical board approached the apex court and asked, should we go ahead with the MTP? Should we inject potassium chloride and kill the child and induce labor? Or should we deliver a live child? The apex court again took this case and then made certain important observation. The apex court said that MTP Act protects the registered medical practitioner and the medical board when they give an opinion in good faith. Hence, it said that the doctor should not approach to the court very often. Whenever they do a decision in good faith, they will not be prosecuted, because there were many cases which were approaching high courts and Supreme Court for asking for permission for MTP whenever it crossed 24 weeks. Further, the apex court also said that the medical board, in forming its opinion for the termination of pregnancy, they should look into the physical and mental health well-being of the mother or the pregnant woman, and that should be documented in their medical report. Further, it also said that if there are any difference of opinion in the medical board, that should be logically explained and also need to be documented properly. And finally, the court also said that consent of the pregnant woman is prime. The consent of the parents will not be taken into consideration if the pregnant woman gives consent. If there is a difference of opinion between the pregnant woman and her parents, the pregnant woman's consent becomes prime. Not only that, it said that even if she is a child or if she is mentally ill or she has mental retardation, the consent of the pregnant woman will be taken into consideration. This was a landmark judgment with regard to medical termination of pregnancy. Hence, the court ordered, since there is a changing consent from the mother and the parents, it said that the medical termination of pregnancy will not be done. The pregnancy will be carried to the term and the child will be born. And later, they can decide whether they will look after the child or they will give for adoption. Not only that, it said, the Supreme Court said that the cost will be borne by the state. So, this was again another landmark judgment where the statutory period was crossed more than 24 weeks when there is a change in consent, and also even the child was raped and the pregnancy occurred. The Supreme Court said, we will not allow MTP here. Again, this landmark judgment was authored by our past Chief Justice of India, Dr. Dhananjay Chandrachud. To conclude, my dear friends, although Indian apex courts have been liberal with regard to interpretation of MTP Act, at the same time, they have not allowed indiscriminate medical termination of pregnancy after 24 weeks. There is no universal rule for all medical termination of pregnancy. Decision should be based on case-by-case basis, and the situation will be evaluated based upon what type of pregnancy, what was the situation, whether there is a grave injury to the mother or substantial risk to the baby. On that basis, the decision will be taken. Further, the apex court also emphasized RMP and medical board should not be dragged to the court, and if they are acting in the good interest of the pregnant woman or they are acting in a good faith, they should not be dragged to the court. Further, the MTP Act 2021 does not differentiate between married and unmarried pregnant women. It said that every woman who is pregnant should have access to safe, legal medical termination of pregnancy so that her life is not pushed for unhealthy abortion. This was a landmark judgment by the Supreme Court. Further, it also said when providing opinion with regard to medical termination of pregnancy by the medical board should assess the physical and mental health well-being of the pregnant woman when the report is given. And finally, the consent of the pregnant woman is more paramount than her parents with regard to medical termination of pregnancy. However, one need to understand There are doctors who are pro-life and they refuse to do MTP. They believe that it is against medical ethics. Doctors are trained to protect life, not to kill life. For example, after 24 weeks, when you want to do MTP, you have to inject potassium chloride to the fetus heart so that the fetus heart stops, then the abortion is induced. That means we are killing. So many doctors are against this idea of killing the child. However, there are many advocates, citizens, activists who advocate for women's reproductive rights and their right to life and liberty and safe abortion. This is a debate which is ongoing. However, the MTP Act is a progressive legislation which has been lauded and also been appreciated by many activists across the world. It talks about women's autonomy over her reproductive choices. At the same time, it prevents indiscriminate medical termination of pregnancy, as we have seen in our apex court decision. To summarize, up to 20 weeks of pregnancy, one RMP can certify and trained he can do MTP. Between 20 to 24 weeks of pregnancy, two RMPs have to certify and then they have to do MTP. Beyond 24 weeks, then if the mother's life is at danger, then one RMP is required to certify and to do MTP. And if there is substantial fetal risk, then the medical board has to certify for MTP. This is all about the recent Supreme Court judgment of India with regard to medical termination of pregnancy amended in 2021. Thank you very much for your time.